All right. Okay, everyone. So then welcome to this next installment of the UQ Philosophy Seminar. Today, our speaker is going to be Joaquin from the La Salle University in Manila, the Philippines. And he's going to be talking about a little bit of logic, a little bit of philosophy. JJ is a great speaker and a great philosopher of logic and everything in between. So I think that we should be in for a treat. Let's see how it goes. And so thank you for being here, JJ, and the floor is all yours. Please go ahead. Yeah.
Thanks for the invite and thanks for the introduction, Guillermo. And thanks for being here, all you guys. Hi, I'm JJ. I'm from Manila, the Philippines. It's sweltering hot here. It's 40 degrees. So I'll talk about legal gluts. So this is a intersection between philosophy of law on the one hand and logical theory on the other hand. Now I'll talk about a particular debate that happened between Graham Priest and J.C. Beale on the existence of a possible existence of legal gluts. Actually, my inspiration was Brad's paper, which was published last year in Inquiry, where he talked about, or he defended Graham's position against Beale's objection. So the plan for this talk is as follows. I'll talk about the issue more, the terms of the debate, Graham's argument for legal gluts, Beale's objection, Brad's qualification, and my take on Brad's qualification. Then we wrap up with a conclusion. Can you hear me well, by the way? Okay, yeah. Thanks. Okay, so what's the issue that we're talking about today? We're talking about legal gluts. And our main question is there such a thing as a legal glut? That is there such a thing as a true contradiction that stems from laws? Now, we all know that Graham and JC are lovers of gluts, but they disagree on this particular issue. So Graham will go for the positive position, and he will say there are, or at least there could be, legal gluts. On the other hand, JC will say, nope, there's something wrong with that position, and I'll show you why. Now, here's the schematic argument that Graham presented in contradiction. Now, let this symbol here represent according to law. So that's the operator that we're working with. And phi here will be any sentence whatsoever. So given a set of laws that we have, for example, Australian laws, Philippine laws, US laws, and so on, we could have this kind of inconsistent, call it obligations. Right? So according to law, phi, according to law, not phi. So therefore, you have that target glut. Now, what's interesting about this schematic argument is that Graham's proof for this has an interesting, let's call it an inferential release. We'll talk about that later. But basically, if you have that release rule, you'll have this proof for your legal glut. Now let's go there. Let's go to release. What do we mean by release? You can think of it as an inference rule such that if you have this kind of sentence, according to law phi, you could conclude phi. You could also think about it in terms of truth preservation. That is, for any sentence phi, if there's no relevant possibility in which O phi is true, but phi is untrue. Now you could think about it as a kind of this is not a logical operation, right? O here is not a logical operation, but actually it's an extra logical operator. We may think of release as a special inference rule for O, such that it holds in all relevant legal contexts. Right, so keep that in mind, because when we get into the details of the arguments, you'll see, or at least you'll have your own take whether that particular rule is valid or not. Now, Beale's counter is that, well, O, that operator that we're talking about, only releases in particular and not in general legal domains. I think in JC's mind, O behaves like other non-releasing operators, like it is possible that, like your diamond, or according to fiction, such that since possibly phi does not lead you to phi, it follows that O phi does not lead you to phi. So if JC is right, then Graham's whole schematic argument for legal gluts is unwarranted. Okay. Now Brad will come in, armor garb will say, well, I'll defend priest's position from Beale's objection as follows. Since laws determine legal rights and obligations, not facts, there is no relevant legal domain in which O phi is true, but phi untrue. Thus, contra Beale, O releases in all relevant legal domains. Again, I'm just sketching out the play of the land, and my take here is that Brad's position, Brad's qualifications fails since it does not address Beale's objection, and second, it does not provide a sufficient case for the existence or possible existence of legal gluts. So let's go to the details of the debate. But first, let's look at the background assumptions that these players are working with. First, the debate assumes a kind of legal positivism. That is, laws are human constructs aimed to govern conduct and behavior. They are grounded on social considerations, not moral ones. They are valid, that is legitimate, if they are enacted by a truly recognized legal system. And in this picture, a valid law implies certain rights and corresponding obligations. Now, this legal positivism is, I think, important, although Brad will downplay it, but I think it's important in the duration of the debate. Another background assumption is the truth aptness of laws and obligations. Now, obligations implied by laws are cashed out as prescriptions of actions of the form, do this, don't do that, and so on. Yet, in this debate, they can be judged as true, false, or a glut. That is, they are both true and false. So you could have an evaluation, a truth evaluation of obligation sentences in this debate. So we're not questioning that as we go along. Now let's get into Graham's prima facie case for legal gluts. And it's really an interesting take, and let's see how it goes. So here's Graham's aim in the whole debate. First, he wants to show that legal systems are wont to produce not only inconsistent obligations, but also dialetheas. And the most cogent way of showing that there are legal dialetheas, that is legal gluts, is to produce prima facie examples and then argue that what they are what prima facie they appear to be. So Graham will give you some examples, right? Wherein laws generate inconsistent obligations, and inconsistent obligations lead you to the target legal gluts. Now, what's Graham's particular case? Well, he gave two, but I'll concentrate on just one here in this presentation. Now, suppose that a particular locale L is governed by a legal system S, and that legal system has the following laws. No person of the female sex shall have the right to vote. That's the first law. And the second law is that all property holders shall have the right to vote. Now you might say, at first glance, you'll say, well, those laws are inconsistent. So therefore, we have legal gluts. But I don't think that that's the argument. Right? 6 and 7 per se are not legal gluts. They don't generate the legal gluts. You might say that they're inconsistent, that's right, but they're not gluts in the sense that they are true contradictions. However, if we consider the case of a particular person, call that person Jan, and Jan is a female property holder who lives in L, Then we have a prima facie case for an inconsistent set of rights and obligations, which in turn implies the target legal glut. So how do we do this? Well, from the laws that we talked about, no person of the female sex shall have the right to vote, and all property holders shall have the right to vote. Now consider Jan, okay? Now let's plug in the according to law operator. So from those two, we'll get, according to the S laws of L, Jan has the right to vote, given 6. Okay? According to 7, okay? John does not have the right to vote. Okay, so do we have a contradiction now? A true contradiction, a legal glut? Not yet. Right? The next step will be using release, right? Using the inference rule we talked about a while ago. So you have the inconsistent obligation, that is according to the S laws of L, John has and does not have the right to vote. Now, these two entail the target legal glut via release and adjunction. Right? So from 8, via release, you'll get John has a legal right to vote. From 9, same inference rule, John does not have the right to vote. So adjunction will give you the target glut. Okay, so that's the glut. Here's the glut. These two are not gluts. These two are not gluts. We're just talking about this glut. So for priest, given that the contingent facts are not at issue, we're not concerned about, there's no debate about the laws. There's no debate about the obligations implied by the laws, right? There's no debate about Jan being a female property holder in that locale. And given as well that the reasoning is valid, the only way to reject the truth of the contradiction is to reject the truth of the statements of legal obligations, right, etc., or else accept legal gluts. Now, as we have assumed, right, we're not questioning the truth of statements of legal obligations, rights, and so on. So we should accept legal gluts. At least that's Graham's main argument. Okay. Now let's see JC's objection to this. I think you could anticipate the moves that JC will make, but let's see. All right, so Graham would say that the reasoning is valid. Peel would say nope, because release is invalid in the case of O, or the according to law operator. The analogy he makes is that, well, take, for example, the case of possibility. We know that possibility statements don't release, right? Since there can be a case wherein possibly phi is true while phi is untrue. Consider the case of 13 and 14 here. Right? From it is possible that there are flying pigs, right? It does not follow that there are flying pigs, because this 13 might be true, but 14 is untrue. Now, similarly, right, so the according to law operator does not release as well, since there can be a case where according to law, phi is true while phi is untrue. Okay. The example is actually funny because he's using the Australian law for drivers. Right? So according to Australian law, drivers drive on the left side of the road, and that thing does not release to drivers drive on the left side of the road. Well, why? Because if we are in the right-hand driving country like here in the Philippines, 15 is true, but 16 is untrue. Okay, so release does not hold in the case of the according to law operator as well. Well, the upshot is as follows. The failure of release in all cases implies the failure of priest's prima facie case for legal gluts. As JC writes, priest's case for legal gluts, for gluts that are beyond system internal inconsistencies, requires a case for the general release behavior of according to law operators. But he has not provided one. And I think he thinks that common counterexamples suggest that one is not going to be found. Hence, that priest's argument is valid in the sense of truth preserving over relevant possibilities is incorrect. Unquote. Now, side note. So Graham made a reply, okay, and he argued that while Jay-Z is right that O fails to release in general, it does so in particular logical contexts. That is, for example, in Australian law, right, the inference from 15 to 16, that is according to Australian law, drivers should drive on the left-hand side of the road, to the fact that drivers drive on the left-hand side of the road is valid within the jurisdiction of the Australian jurisdiction. So while O fails in general, O might not fail or might hold in particular cases. But I'm siding with Brad here because I think Brad was correct in pointing out that this maneuver does not work, since by granting that the O operator does not in general release, priest Graham seems to be ignoring the fact that it follows that release for according to law is invalid. So that is, I think, if we're willing, like priest, to restrict the scope of your or the role of your release operator, sorry, the O operator in the function of release in legal context, if you are willing to accept that it's valid in just particular context, then it's not valid in general. So that's the side note. Okay, so how would Brad say the priest position from Jay-Z's objection? Here's Brad's argument. Jay-Z's Australian law counterexample is misdescribed since a law dictates or determines certain rights or obligations, but a law is not in the service of determining any matters of fact. In short, laws determine rights and obligations, not facts. I think this is a crucial distinction. So you have the scope of law being rights and obligations, not facts. Right? That's the distinction that Brad is making. The implication is that, yeah, JC is right, that 15 does not release to 16, but a qualified version of this thing here releases to a qualified version of 16 there. The qualification here, of course, is that the scope of the according to law operator are rights and obligations and not facts. So here's the qualification. Here's Brad's way of undermining JC's objection. So notice the distinction between 15 and 16 here and 17 and 18. So 17 tells you, according to Australian law, drivers in Australia are obligated to drive on the left-hand side of the road. So therefore, drivers in Australia are obligated to drive on the left side of the road. Now compare this with this one, which talks about facts, supposedly. Okay. So in this case, since there is no relevant legal domain in which 17 is true and 18 is untrue, it follows that O releases generally, not just in the particular case, in the Australian case, but actually it releases even in the Philippine case. Because here, even though we are a right-hand driving country, it still holds, a 17 still holds and 18 still holds. So, matalis matandis, O also releases in priests case. So that's Brad's way of defending Graham's position. Okay, so I'll come in. I'll say that there's a problem with Brad's qualification. albeit it has a certain pull. If you're convinced, then fair enough. Okay. But I think that it still does not address Peele's main objection, and it does not preserve release behavior of O, nor does it preserve Graham's case for legal Gluts. That's the main point of this talk. Here's my contribution to this debate. Okay. First, let's talk about the scope of O. Consider again Brad's idea that the scope of the according to law operator are rights and obligations, not facts. This means that phi in this formula, O phi, represents obligations, not facts. Here's the counterposition. Said contra, on the contrary, suppose that phi does represent facts. In this case, the intended reading of O phi is that it is obligatory to bring about fact phi. So here's the claim. Okay? Phi represents facts. And the fact here, the intended reading of the fact is that it is obligatory to bring about fact phi. For instance, consider again the case of 15. According to Australian law, drivers drive on the left side of the road. Given its intended reading, it means that according to Australian law, it's obligatory to bring about the fact that drivers in Australia drive on the left-hand side of the road. However, this means that that reading expresses the same thing as Brad's reading or Brad's maneuver a while ago. Right? That according to law, drivers in Australia are obligated to drive on the left-hand side of the road. Okay. So if it means that these two things are express the same thing, same proposition perhaps, same meaning. Now, since 15, okay, the case, Beale's case, is not release, and these two are similar, it follows that Brad's case does not release as well. Given this, it follows that Brad's qualification is unnecessary. Right, so that's the first objection. Now, Brad might reply. Actually, I received an email concerning this. That this objection seems to only apply to obligations, not rights. So we've been talking about rights, obligations for the past few minutes, but not rights. But priests, prima facie case of John, okay, is about rights, the right to vote. So granted that the objection holds for obligations, it does not really hinder the prima facie case of Graham. So it might still push through. Now here's my offhand response to this objection, to this reply. Well, that's right, laws do imply rights, but with corresponding obligations. Now think of the right to basic education. So government, so our laws, I think it's a universal law that all of us have the right to basic education. But that right has a corresponding obligation, right? Some other person or some other government or some other state. So those people in government are obligated to give us this right to basic education, or at least to open the possibility for us to practice such right. So you can see that there's a kind of symmetry between rights and obligations, such that you could define one using the other concept and vice versa. Now, since there's a symmetry between rights and obligations, and release fails in the case of obligations, it follows, I think, but release also fails in the case of rights via this symmetry argument. Now, another concern that I have with Brad's qualification is that it kind of implies a roundabout way of restricting the scope of O. So the qualification in Australia in Brad's formulation here, specifically this part here, According to Australian law, drivers in Australia are obligated to drive on the left side of the road. I think it's redundant. That is since according to Australian law operator, already implies the locale in which the law applies. As such, deriving by the drivers in Australia are obligated to drive on the left side of the road from the redundant premise seems to beg the question against Peel's objection. Okay. Another email that I received regarding this objection. So perhaps Brad might push back against redundancy and maintain that he's talking about what drivers should do in Australia. Drivers in Australia drive on the left side of the road because Australian law says they should. However, drivers driving on the right side of the road in the Philippines does not make the Australian law on driving untrue. This then supports the in Australia phrase there being non-redundant in this particular formulation. My response is that I think this pushback does not work because it seems to be more of a restatement of Brad's position rather than a rebuttal of the redundancy charge. Now we can talk about it in Q&A if this response works. Okay, finally, I think I have good time. I think here's the main thing that's underpinning JC's main objection. I think that Brad fails to address this main insight, JC's main insight. So what's JC's main insight? I think it is that the role of release, that inference rule, and generating genuine gluts, as opposed to mere gluts or semantic gluts. Talking about genuine gluts, real gluts. So consider the case of the operator T, top, in generating the liar paradox. For glutty theorists like Guillermo here, perhaps Ross, and other people here who like gluts, the liar paradox, which stems from the liar sentence, this very sentence is untrue, lambda, it's the standard case for gluts. And the paradox, as we all know, is generated by top's capture and release behavior. Capture implies, you know this, for any sentence phi entails stop phi, and release implies that top phi entails phi. We all know this. And we all know the proof for the liar sentence given these rules, for the liar paradox given these rules. You see the function of release, you see capture here, and so on. So this is the standard way of proving the liar paradox using capture and release. But the details of the paradox do not matter here. We're not concerned about the paradox itself. What matters is that we highlight how the paradox is generated by top's behavior. Top is one of our totalizing concepts. It encompasses all of the things that are true. Top is important to us. It's true. We love the truth. So for glutty theorists, since it generates a paradox, the only way we could hold on to top, sorry, that's a typo, is to embrace its glutty nature. Now, I think the same line of reasoning applies to other totalizing concepts that generate other paradoxes, since they come from applying our concepts to their limits, from the boundaries at the limits of thought, as Greg would say. Okay. However, as you can see, unlike top, O, our according to law operator, is not a totalizing but a restricting concept. By its very nature, the according to law operator does not encompass all laws. It restricts actually the content of its content to a specific jurisdiction in which the law applies. So it does not talk about the boundaries at the limits of law. So the inconsistencies that O generates do not go beyond, but are internal to the given jurisdiction. As such, M's prima facie case for legal gluts, i.e. the case of Shan, having and not having the right to vote, does not have the same pull as the liar paradox generated by Tom. The liar paradox, I think, pulls us to accept the liar glut, okay, or liar gluts. But Graham's prima facie case does not do this. It does not pull us. I like the metaphor of pulling or to a particular position. Okay? Instead of pushing. It does not pull us to accept legal gluts. It only confronts us with peculiar inconsistencies generated by an inconsistent set of laws. So I think, okay, it's good time. Conclusion. So here in this little talk, this is still a work in progress, and I'd appreciate your comments and suggestions later. But I think we have looked into the pre-view debate concerning the possible existence of legal gluts and Brad's defense of Priest's position. I've shown, I hope, that Brad's qualification does not work since it fails to see the main insight behind Thiel's objection. And that main insight is that O does not release. Actually, that's not the main insight. The main insight is that, unlike other totalizing concepts, O does not generate genuine gluts, since genuine gluts are beyond system internal inconsistencies and are generated by our given totalizing concepts, capture and release behavior. That's all for me. Thank you very much. If you're interested to see the references, it's here. Right. Thanks, and I'm waiting for your suggestions and comments.